Our next speaker is Greg Willis. Greg here he's been a super lawyer year after year in DUI defense, and his success rate is 93% without a DUI conviction over the last 7 years. In fact, there was a time when Greg went so far as to defend one of his clients to spend 4 days in jail in defense of his client. I understand that he ended up getting a lot of clients out of that and played a lot of basketball down at Rice Street, or was it Atlanta City?
It was Atlanta City.
Oh, so it's like city pretrial down there. But Greg has as much training as you can get as an attorney in DUI defense, and he's on the board of directors for the National DUI Defense Lawyers Association. He has successfully appealed numerous cases to Georgia's highest courts and has petitioned the United States Supreme Court in numerous cases. He's a graduate of the University of Georgia Law School from 1996 and has always dedicated his practice to defending Georgia drivers accused of DUI. And he's going to talk to us today about all of the fun stuff going on right now with paragraph 16 self-incrimination issues and all the appellate issues involved therein. Thanks, Greg.
Thank you, Kevin. I appreciate that. And thank all of you today for that welcome. I appreciate it. And it's an honor to be here to speak about what I've been kind of living through for the last 5 years, kind of therapy to talk about it a little bit. I've got a pretty boring topic when you talk about legal arguments, and we're just talking about the nuances in the law in a lot of ways. And I look back and I think, I thought to myself, I said, why do I get excited about this topic? What makes me excited? And I thought back about my grandfather. Sherman Robbins was his name, and I remember him strutting around the house when I was a kid talking about fighting in World War II and talking about the rights we have in this country. And he would stick his chest out and walk around and talk about, all the things he did and that we did as a country to have all the rights that we have. And you're talking about fundamental rights as in the Fifth Amendment, the Sixth Amendment, all the Bill of Rights, the right to vote, our free society that we have. And I think about that, and that's really what drove me into being a defense lawyer was him. And you think about guys that lost their lives and families that lost their brothers and fathers and family members. But just think about my grandfather, Sherman. He went to Europe for 4 years of his life and couldn't work, couldn't provide for his family, and spent time away from his family and came back and saw some of the most terrible things you could possibly imagine. That he told me about some of them. I certainly didn't hear all of them. But even that 4 years that he came back was a heck of a sacrifice to make for these rights that we have in this country. And that's really what we're talking about today, is how those fundamental rights are being viewed by our courts. And really the goal of our courts, in my opinion, is to protect those rights. So that's what kind of gets me excited when I start talking about these, what seem to be fairly trivial, stupid legal arguments. And we've got a case right now that is at the Supreme Court. It's Elliott is the case that is really talking about self-incrimination. And I've been asked about that case probably 300 times in the last 2 weeks because we expected a decision out on that case by the end of the August term, which was before the first Monday in December. Well, I called the Supreme Court today to find out what the scheduling issue was, and they explained to me that when they redocketed the case after oral arguments, they docketed it to the August term and not the April term. So to give you a little background of how the Supreme Court works, the date of docketing is not the date of docketing at the Supreme Court. So when you look online, this case was docketed in December of 2017. They held it approximately 12 months before they docketed it. They waited to decide OLEVIK before they actually docketed it, but they just held it, and I'd actually forgotten about it. The docketing date, though, is not the term it's docketed to. They actually choose the term that they docket it to. So they docketed it to the April term, and that's, of course, when we had oral arguments in April. And they then docketed again that week after we had oral arguments, but they docketed it to the August term. So the decision in this case is now due out before the first week in April rather than the last day in November, which would have been a business day, which was November 30th. So I did solve that riddle before I got up here to tell you something definitive about the case. But the reality of where we are with the case is pretty interesting how the state has changed their arguments. They've gone from trying to make an argument that it can't be used to their new argument that they've been making. I'm going to get my PowerPoint going now. I had a lot of technical issues today. The state has gone from arguing that there's no way we can use the refusal. They want to use it against my client was their first argument. Now they've almost given up on that, and they're now arguing that they want it in to complete the evidence. So it's gone from an argument that absolutely the refusal comes in, it's admissible, can be used against your client as incriminating evidence, to now, well, we want to just tell the jury what all the evidence was to be fair to them. And it's pretty funny when you look at the history of this argument and what we're doing. And I don't know if that's big enough to see in the back. Let me get this on the slideshow here. So there we go. Can you guys see that in the back? I couldn't see most of what George did, so I decided to enlarge in mine while I was in the back there in the back. I'm just kidding. I did this beforehand. So we go back to the 1800s to look at the law about self-incrimination, and we're talking about this case is discussing a privilege that you have a right, and whether, and they're using some language here, Old English, about incriminate or subject to penalties. They're talking about that you can't be bound to accuse yourself directly or indirectly. This was the prevailing law of the land of the United States back in the 1800s. Most states agreed that not only were statements inadmissible, but you couldn't be required to do a lot of things that in Georgia we still have. So Georgia's Constitution still protects us from doing anything that requires an act, such as a handwriting exemplar, such as putting your foot in a track was one used in a day case. And then, of course, you have a Creamer case, which was decided in '72, where the Supreme Court did a great analysis of the removal of a bullet from a suspect in a murder case in Cobb County. And the analysis was about whether he was required to act or not by agreeing to that bullet being removed. And they found out, and they held in that case, since he could lay there and do nothing and the bullet could be removed, that was not protected by paragraph 16. So this was actually the general principle that came into our Constitution at the beginning and seemed to be fairly consistent through the 1800s with most states. Well, we are now one of the very few states that protects you from an act. We do it, and Massachusetts does it to some extent. And what that means is you still cannot be required to act in Georgia. So if you're required to do something to provide evidence, that's protected in Georgia. So Harrison Powers kind of laid it out and talked about of what worth would the protection be if a party availing himself of it incurred detriment or loss by doing so. So then we've got the McNeely case, and I wanted to do something. I'm going to change my direction or order I'm doing this in real quick. I want to play a clip. Has everyone heard about the Grant case at the Georgia Supreme Court? Very, very interesting argument that y'all are about to watch. Probably more important thing I can tell you is what you're going to see here, if it works.
Court. The trial court correctly denied Mr. Grant's motion to suppress the statements he gave to police on the ground that Mr. Grant did not unambiguously and unequivocally invoke his Miranda rights before officers left the room.
At any point?
Yes.
The trial court is right in saying that he never unambiguously invoked his Miranda rights?
Your Honor, the state's position is that he did not unambiguously and unequivocally invoke his Miranda rights before the officers left the room.
That is a very hard thing to credibly stand up here and say. given statements like, do I want to waive my rights? No, I'm not waiving anything. You don't want to talk about this at all? I mean, that's only part of it.
Am I under arrest? Then I don't got nothing to say.
Well, certainly he made statements that he did not want to speak to the police.
That is an unequivocal invocation of the right to silence, right?
Well, the state's position is that certainly he made statements that he did not want to speak to the police.
That is
but
an unequivocal right.
As to whether or not his statements were unambiguous and unequivocal, it is the state's position that the police were entitled and pursuant to the law.
Can you
they
cite
had
a
to advise.
single case that supports the idea that when a defendant says, not just once, but this many times, unambiguously that he doesn't want to talk, that he has not invoked his Miranda rights?
Well, Your Honor, Justice Blackwell, the cases that
Justice Peterson.
I'm sorry, Justice Peterson. The cases that the defense, the appellant relies on, they're all cases in which the appellant, the defendant, the suspect was advised.
I didn't ask about their cases.
Yes.
I'm asking, do you have a single case where the defendant said this many times he didn't want to talk, where an appellate court said that as a matter of law, he did not invoke his Miranda rights?
Well, they're not cases on either side.
Yes, sir.
Because they're cases.
You don't think we have cases, I got nothing to say. That is not an invocation of the right to silence?
But Justice Namias, those cases were when, those situations were when the defendant had been advised of his Miranda warnings.
Okay,
In this situation.
So I think the trial court said, you only get to benefit from the Fifth Amendment if you're told about the Fifth Amendment. But for example, if I were arrested as a Supreme Court justice, and before the police advised me of my Miranda rights, I said, I do not want to talk to you. I am invoking my Fifth Amendment rights under Miranda to not talk to you. I will not say anything to you. I am invoking Miranda.
Completely different facts.
No, but the trial court says until you get your Miranda rights, you can't invoke your Miranda rights.
Completely different facts,
So
Justice
what are
Namias.
But that's what you just said. Those cases are cases where the defendant had already been advised of his Miranda rights.
Well, Your Honor,
What authority do you have for the proposition that you can only invoke the rights that Miranda tells you about if you've been told of your Miranda rights?
Justice Namias, what you have just set up was a completely different set of facts than what we have here. These officers didn't know this defendant from the man on the moon. They did not know.
This is my legal question.
Yes.
You said the legal distinction from the cases where words like this have been found to invoke counsel, and the trial court said the legal distinction is in those cases the defendant had been told of their Miranda rights, and then they say, I don't want to talk. My question is, what authority do you have for the proposition that the rights protected by Miranda can only be invoked after you're told of your Miranda rights?
Well, Your Honor, as I said, it depends on the circumstances. It depends on the circumstances. Your Honor, Justice Namias, you are a lawyer. You are a learned scholar of the law.
Let's
if
just
you
take
invoke
a
your
regular
right,
defendant who has been advised, who's been.
So the reason I think that is so important is because how many times do you think that's happened as far as someone's rights being violated at a motion hearing or at a trial before they ever would get to the Supreme Court in this state? We're the only ones that can stop that. We've got to raise objections and got to fight for these rights that are our fundamental rights. And that is a little bit disturbing to watch a prosecutor argue that. But what's even more disturbing is there's a guy sitting in prison right now where the co-defendant was acquitted at trial. There were no statements that he made that were admissible in court. This gentleman, Grant, did get convicted, and that is one of the reasons they reversed the conviction of Grant, was because it was obvious that the evidence was so similar between the two defendants, and one was acquitted and one was convicted. So now we have a guy in prison right now that's been sitting there due to this case. And this obviously has taken a long time to percolate through our courts to get there. So the prosecutor had the video before the motion hearing ever happened. The prosecutor then argued to the judge to let the evidence in, contrary to well-settled case law. The prosecutor then gets a conviction on the case with this evidence and argues all the way to this point that the conviction is valid. There are points in this video where I think Justice Blackwell was the one that used the language of, I don't think your other argument's necessarily a winner, but it's less frivolous than this one. And I mean, you literally should get this video and watch it in its entirety sometime. And it just shows you how important it is for us to go in there and fight for our clients and for these rights that we're trying to protect. So now I want to give a little background of how we got to where we are today. And I'm still struggling technology-wise, but that's okay. So Missouri versus McNeely in 2013 is what I think changed the entire universe as far as DUI laws go. And to start my explanation of this entire topic, I do not think breath tests, blood tests, or refusals are admissible under our current statutory scheme in Georgia. I think our entire scheme is incorrect based on the U.S. Supreme Court's decision in 2013. In fact, April 2013, that case was decided. And the reason that everything changed that day was because the U.S. Supreme Court declared that we have a constitutional right to refuse testing in a DUI case. Before that, we were relying on Schmerber that indicated that there was a exigency created by the dissipation or elimination of alcohol that allowed the state to get a blood test without a warrant. And McNeely obviously decided that that was no longer the case. And one of the major issues in McNeely and the language that they explained was the electronic warrant statutes that have been passed in every single state. So they cited to even Georgia's electronic warrant statute when in all of them, and a full page was taken up citing to all those statutes, but they indicated, the justice did, that there was no problem with the delay that there was back in 1966 as compared to 2013. So that was the big breakthrough, in my opinion, that changed all these things. So I start arguing in 2013 about this, and I swear to you, judges were looking at me like I was completely insane. And after I argued, filed a brief, filed motions, and we sat there for 2 hours talking about it, the judge would then go, "You mean to tell me that you think the implied consent scheme is unconstitutional, Mr. Willis?" I'm like, damn, 2.5 hours and 75 pages later, you finally figured out the issue we're arguing about? Yes, Judge. Are you a Harvard graduate? I mean, that's pretty good. You finally got this figured out. And literally, judges would argue with me about the most minute things. They would ask me about, do I have a case showing it's the implied consent warning can't be read or can't be used, and all these silly things about of where we were. And this is kind of how I felt like this process has gone, as far as, first of all, I'm getting ridiculed by judges about even arguing it, how absurd it was that we'd have a constitutional right to refuse testing. And of course, the breath and blood are whole different issues, but we're going to get to those in a minute. Then it's violently opposed, and then everyone's like, oh, it's obvious. And we haven't gotten to the obvious point yet, but I sure as heck hope when we get a decision in Elliott that that's where we are and that's where we stand. So I'm going to talk a little bit about Birchfield also, because we had two big cases come down from SCOTUS on these tests. The first case was obviously McNeely, and it was followed by Birchfield. And Birchfield is an extremely interesting read when you talk about a blood test. I don't think a blood test can be compelled under our implied consent scheme. The holding in Birchfield was directly related to a state, North Dakota, or two states, North Dakota and Minnesota, that criminally prosecute refusal. So we're in a little bit different situation, but they're talking about a lot of what the discussion is about the intrusive nature of the blood test versus the accurate alternative of a breath test. So they're talking about the blood being a problem in the Birchfield case. So we've got three different scenarios. How crazy is it that all of them start with a B? Birchfield, Bernard, and Bayland. So Danny Birchfield refused blood, William Bernard refused breath in Minnesota, and Bayland submitted to a blood test in North Dakota. And they looked at all of the cases and decided that you cannot compel a blood test is the holding of it. And unfortunately for most states, they found that you could compel a breath test because that was a search incident to arrest. And they did not have protections in most states like you have in Georgia to protect you from an act. So I think we're in a completely different ballgame as far as that goes. So this is language out of the Birchfield case that's very helpful to us because the defendant in that case submitted to the actual blood test, but they said that the North Dakota Supreme Court erroneously held and did not consider the fact that the state could not permissibly compel the blood test. So they couldn't be forced to do that. So they had to send it back to the North Dakota Supreme Court for further findings on whether, after giving erroneous information that he was required to submit to the blood test, whether that blood test was still admissible. One of the things that North Dakota has in common with Georgia is at that point in time, North Dakota's implied consent warning had the exact same language as Georgia. It says you are required to submit to the test. A lot of other things were in there about it being a crime not to submit to the test, but the language about taking the test was exactly the same. So they talk a little bit about the blood test here, and even start talking about the convenience in collecting evidence, the burden of asking judges to issue an extra couple warrants per month are costs so high as to render reasonable a search without a warrant. And they found that it does not and cannot comply with the U.S. Constitution under the Fourth Amendment. So we got great language about the intrusive nature of that, and then it follows up with an empty promise of protecting citizens from unreasonable searches. Very different decision than we got in 1966. And then it goes on to talk about the criminal penalties and that there must be a limit to the consequences that a motorist has agreed to just by driving on the roads of the state. So what they did was North Dakota changed their implied consent warning after the decision in Birchfield. And they removed blood tests from the list of things that they were required to do, and it being a crime. And also went into and specifically stated that the only way that a blood test could result in criminal penalties would be after a warrant is secured. So that was consistent with McNeely and also consistent with Birchfield. Our state, PAC, General Assembly, all the above, has still not changed our implied consent warning as it relates to these cases. When I read McNeely back in 2013, I literally looked at it and said, man, they've got to change the warning. I naively thought, hey, somebody at PAC is going to figure this out and get this warning changed in a hurry, and we're going to have this problem solved. But we'll have a new implied consent warning. It'll be very interesting to see how they change it, what they do to comply with the new cases from the U.S. Supreme Court. Because our warning is now completely inconsistent with what the holdings of Birchfield and also with McNeely, because according to McNeely, you need a warrant to get a test from someone who's not cooperating. They have a constitutional right to refuse. So the other thing that I think is important is every time a prosecutor, a judge, or anybody mentions Neville to you, you can stop listening. They have no idea what they're talking about. Neville is a case from 1983 that specifically addressed the fact that the right to refuse was statutory only. It was not a constitutional right. So it has no bearing on a DUI case at this point in time, based on McNeely saying we do have a constitutional right. So what Neville did was Neville explained that when you have a statutory right, and the General Assembly has defined that right, they can punish you however they want. They can penalize you with a license suspension. They can penalize you with using the evidence against you at trial. And there's nothing wrong with that because it's a statutory right and not a constitutional right. So I am, in my opinion, I feel like Neville doesn't have any bearing as far as where we're going with this argument today. And I still hear prosecutors argue about Neville and judges argue about Neville to this day. I'm still hearing it. And I don't understand the relevance. So if you look at our warning, this is where I think we have problems for breath test and blood test, is because of the language of our warning. One, I don't think you can use the refusal against someone because it's exercising a constitutional right. But number two, you're being told you're required to submit to a state-administered chemical test that you have a constitutional right to refuse. We know after OLEVIK we can refuse a breath test. We know after McNeely we can refuse a blood test. We know after Birchfield a blood test request is not even reasonable according to our U.S. Supreme Court. The other part about this warning that I think coerces you into submitting to a test that and it would result in a breath test or a blood test being suppressed is the language about if you refuse this testing. And I'm not talking about the driver's license. I don't think you can be suspended for refusing a blood test, but there's certainly an argument to be made for the state in that case. The last sentence, I don't think the state has an argument they can make with a straight face, unless you're from the Fulton DA's office and arguing in a grant case, I guess. Your refusal to submit to the required testing may be offered into evidence against you at trial. I do not believe that if you've got a constitutional right, whether it's the Fourth Amendment or under paragraph 13 or 16 under the Georgia Constitution, I don't think they can be used in evidence against you at trial. OLEVIK went on not only to grant us the constitutional right to refuse a breath test, but it also specifically mentioned to the General Assembly. This is obviously has no bearing on the case, the decision, or anything else, but they indicated that the warning that they're reading people needs to be more accurate. I think the Supreme Court was speaking volumes with this footnote. The state has still not modified its warning that people are being read to this day. Now, I was going to play that and tell you what I said in front of the Supreme Court, but that's not working. But I can tell you what I said. I said that basically we have a fundamental right here, which is the right not to incriminate yourself. And that when my client, Elliot, exercised that right by saying, I'm not going to take your breath test, she's invoking paragraph 16 and saying, I'm not going to incriminate myself. And by asking the court to admit that evidence against her is doing exactly what has been held could not be done through the history of our country. And our paragraph 16 is very different than the Fifth Amendment. Our paragraph 16 protects acts, not just statements. But the one thing we have done consistent with the Constitution of the U.S. is we have always evaluated what happens when someone invokes those rights in the same manner. So if you say, I'm not going to talk to you after being read Miranda warnings, that doesn't make it to the jury. If you say, I want a lawyer, that doesn't get in front of a jury. So the investigation of them interrogating you and asking you any questions doesn't get to the jury. And what I told the court that day was that's exactly what they're asking you to overrule is these holdings we've had since the 1800s. So I'm going to move on to the next one. See if I can get the next one to play. This is Mr. Will Fleener. And I know Will is doing what he's told to do. I'm not giving Will a hard time, but the argument has been created by PAC, and let's see if I can get it.
And the reason that we know that is we did thoroughly research the issue to try and determine whether or not the Fifth Amendment and paragraph 16 have been declared to be fundamental rights. And we were unable to find a case that even said the Fifth Amendment was a fundamental right.
That's because it strikes me as rather ridiculous to claim that a right that is textually in our Constitution and the federal Constitution in the Bill of Rights is not a fundamental right. Are there any other rights in our Bill of Rights, Georgia or U.S., that you say are not fundamental rights?
Well,
So that is literally what the state is trying to argue, is that they want to basically ignore all of this case law involving the Fifth Amendment and paragraph 16. And this case, Underwood, is probably one of my favorite quotes that I found. And as y'all can probably tell, as excited I am about this boring stuff, I do like researching and finding cases like this, where you're talking about what we've done to be here today. I mean, this quote is unbelievably important, and the Fourth and Fifth Amendments are so intertwined in a breath test case because you've got the Fourth Amendment right to in regards to a search, and of course paragraph 13 of the Georgia Constitution, and you've got the Fifth Amendment, which is self-incrimination, similar to paragraph 16. And they're intertwined in these cases, and this case literally talks about there being sacred jewels forced from the unwilling hand of tyranny, and that's exactly what we have in our country. They're hallowed by the blood of 1,000 struggles. I mean, these are important things that our Supreme Court has done a great job with for the most part. We've had a little bit of problem with breath testing in the past, where Clink, I don't think, was decided correctly, but it seems to me our Supreme Court does a good job, generally speaking, and I did want to explain a little bit about my thoughts on the Supreme Court with the recent case that came out. If anyone does a lot of drug trafficking cases, there's a case from the U.S. Supreme Court in 2015 that the argument where a de minimis intrusion or violation or extension of a traffic stop had been permitted by the U.S. Supreme Court, that ended in Rodriguez in 2015. And what the Supreme Court was swayed by, the U.S. Supreme Court was swayed by in that case, was that if they already had someone stopped, that to continue to stop them and ask them questions was a de minimis violation and therefore permitted. I never understood that. How can you have a de minimis constitutional violation? What the heck does that even mean? The violation's all I need to know about, and at that point in time, the stop should be over and we should be done. Well, our courts got it right. They've had it right, Sims and Simmons, in a bunch of cases from the 2000s, early 2000s, before the U.S. Supreme Court got it wrong. Well, now the U.S. Supreme Court has now followed the Georgia court's lead from, and I know they didn't follow their lead, but they followed where we were long before them, and they've now found in Rodriguez that de minimis intrusion is no longer valid. And that seems to be what the state is arguing in this case, is that they can violate rights as long as they aren't violating them very much. And it's just an interesting argument. And that's the rest of the quote from Underwood about being sacred trust and the keeping of the courts, who should with sleepless vigilance guard these priceless gifts of a free government. And that's those are the things that the courts I really think is important for every judge to understand when they're looking at these cases, and instead of just saying, look, I'm going to wait for the Supreme Court to decide this, I'm going to deny it and not think about it. It's very frustrating when we start talking about the rights we fought for in this country. So the result is that the rubber hits the road in the courtroom. I mean, we can fight all these wars and have their Constitution valid and everything else, but if we're going to constantly erode our rights in the courtrooms, where all of us go to battle constantly, then we have nothing. All these rights on paper don't mean anything. So we've got to have the judges following up and doing these things and granting motions and following the Constitution. So this is the language that has been part of our Georgia Constitution forever. Every single time we ratify a new Constitution, it ends up being the same language. That language, and that was part of the OLEVIK decision, was that the language of our Constitution never changed, so why should the interpretation of it change, like the prosecutors in Gwinnett County have been arguing very strongly about? Sam D'Antremont has done a great job from a legal standpoint. He's written thousands of pages about it, but it's just a very difficult argument to make when our Constitution was interpreted back in 1879 following Iowa cases prior to that, and it's always been that you cannot be compelled to do an act to incriminate yourself, and that's what the breath test requires. You have to do an act to submit to a breath test. They can't walk up to you while you're asleep or while you're unwilling to do it and make you blow into a tube, and that's the reason that we are protected in Georgia very different than every other state. And we also have a statute, 245506, and when you see it in case law, a lot of times they refer to 24-9-20, I believe, is the old statute, but this is the statute that mirrors our Constitution in protections. And then I have a lot of cases or language from cases where they're talking about these rights and how these rights need to be applied. So if you ask me what my opinion is on the implied consent warning in Georgia and what is admissible or not admissible, I may end up being wrong about everything according to the Supreme Court of Georgia. But I promise you, I will lie in my grave and believe that I was correct. I do not know how we can have these constitutional rights as they've been obviously challenged for 100 years and more, and every single time we've had the same response. And that response is when you exercise your right not to incriminate yourself prior to trial, it's not admissible against you. And that's what the Elliott case is about. And the question when you have in that case is, how in the world do you explain that to the jury? We're going to tell them my client has a right not to incriminate himself and therefore he didn't do that? I mean, that language in and of itself is going to be very difficult to explain to the jury without a negative consequence. And that's why we've always kept out the Miranda discussions when someone says, I want a lawyer, I'm never talking to you, I hate police, whatever it may be, or I ain't got nothing to say, as Mr. Grant told the police officers in his case. So I don't know how they can change the framework now this late in the game, and I hope they do not as far as the Supreme Court goes. And these cases that I've got up here talk about the privilege and how important it is to fight these things. And there's all this great language in our case that when you exercise constitutional rights, it's not to protect the guilty. It's a shield for the innocent. It's to protect the innocent from being harassed and bothered and stopped and held on the side of the road. All of these things are a fabric of our society that we're used to, that we appreciate. And our founding fathers and our framers clearly appreciated those things and went to great lengths to make sure we had those rights. And these cases that you get, when you start getting back into the 50s and 60s before the DUI Constitution exception came into being, where they started kind of trying to write laws to allow the DUIs to be prosecuted, then that's where you get great language about these different rights. And it says, neither by enacting a statute nor a court through its actions may exact a price for the defendant's silence in a way that hinders the exercise of his Fifth Amendment rights. I mean, how clear could that be about someone who under OLEVIK has a right to refuse a breath test and they say no? I mean, it's just so simple. Mitchell's a great case talking about it. We're talking about the government must prove the allegations while respecting the defendant's individual rights. So this is the brief from the state in my Elliott case. Given the options for maintaining an effective statutory scheme, introducing evidence of a refusal is a minimal violation of a person's privilege against self-incrimination. I mean, they're admitting basically that they want to violate your client's constitutional rights in order to prosecute them, and that you should ignore that minimal violation. It really does remind me of the de minimis argument, and that actually was well received by our Supreme Court for a while, not of Georgia, of U.S. Supreme Court for a while, but now has been reversed by Rodriguez. Now, this is the argument that they're making. That's exactly what the state has argued over and over and over again, is that you can't do this. We can't prosecute another DUI ever again. And Justice Blackwell actually asked Will Fleener about his Chicken Little argument, used those exact words about that in the oral arguments, because that's exactly what it is. They're trying to invoke emotion into an illegal argument about how they're going to prosecute a DUI in the future. And I can't remember who argued about that. I think Jeff Rothman in his argument in Garvin actually mentioned to the Supreme Court that they prosecute DUIs all the time with no breath test and without a refusal. It never gets mentioned, implied consent isn't mentioned, and they just prosecute the case with the evidence that they have. And we all have seen plenty of cases where clients are falling down drunk, looking terrible on fields. When they get handcuffed, they go, oh, you got me, I'm sorry, I shouldn't be driving, I know it. I had a guy at a roadblock recently that literally looked good on fields, got arrested by the police. He goes, yeah, man, I knew I shouldn't have been driving. And I'm like, what in the hell is going on here? Because his fields were good. He had, I think there were 6 on HGN, 2 on the walk and turn, and 1 on the one-leg stand. So he actually passed the one-leg stand. So instead of arguing with the police, he's telling them I shouldn't be driving. So we have plenty of cases that regardless of that, they've got evidence that they can certainly go forward on. Maybe not win all of them, but certainly go forward on them. I thought it was funny when Justice Blackwell called him out for it. So in this Spivak case, great language about find no room in the privilege against self-incrimination for classifications of people. People being one a DUI arrest versus a murder suspect. And that was one of the conversations that Justice Namias had with Will Fleener in the Elliott arguments was, he says, well, what's more important, murders or DUIs? And of course, Will said murder. And then he said, well, we don't introduce evidence of the detective going to the jail, talking to the murder suspect, and him saying, I'm not going to talk to you, I don't want to discuss the case with you. Why would we do it on a DUI case? And then he said, Will really messed up now, he said that everyone expects a test result or refusal in a DUI case. So then Justice Namias wanted to know his research and his sites for that information and where he got that from. And of course, there was none. But, you know, that's the problem is, of course, it would be better for the jury and for the state if they could say, look, we went down to give the guy a chance to exonerate himself. He didn't want to talk to us. He didn't speak to us. He exercised his right to a lawyer or whatever. But how do you ever explain that to a jury without talking about self-incrimination and that they didn't want to incriminate themselves, they wanted a lawyer? All very negative consequences. In my opinion, for how the juror would view that case. So I don't think we are really plowing new ground here with what I'm arguing. This is Marlowe. I love this. I love it about holding otherwise would encourage use of oblique and indirect methods to erode a substantial. And that's exactly what the state's asking to do. They're asking to admit it, but then not necessarily get an inference about it being and what your inference is in Georgia is in regards to the refusal is that the test will be positive for whatever the prohibited substance is, whether it's alcohol or drugs. So it's not the worst inference in the world, but it's still incriminating and it's still part of the case that the state's got to prove. So we then look at Ullman, great language in this case. And this obviously is another old case talking about the patriots that sponsored the Bill of Rights and the Constitution, and that we couldn't change those privileges and rights. And I mean, this language is just wonderful. And they're talking about the founders of our nation not being naive, disregard the interests of justice. And they're talking about we're not just trying to make the job of law enforcement difficult. The framers knew this when they drafted the Constitution. We specifically agreed, I think as a nation back then, that we are more concerned with innocent people going to prison than we are with getting every single guilty person. And I mean, clearly guilty beyond a reasonable doubt is for that. And we're trying to avoid innocent people being convicted of crimes. And they're talking about if liberty is worth keeping and free representative government we're saving, we must stand for all American fundamentals. And this is what the issue is with our DUIs. The state wants us to obviously curtail our privileges against self-incrimination and also our privileges to have a lawyer or any of those rights in order to prosecute DUIs. And this case is great also, Griffin versus California. This was probably the best language of cases from our U.S. Supreme Court coming into the 60s. And it's talk about a penalty imposed by courts for exercising a constitutional privilege. It cuts down on the privilege by making its assertion costly. Our Georgia Supreme Court was saying this back in the 1800s. I mean, we've got great language from numerous cases that we cited to where it's saying, what kind of a privilege do you have or a constitutional right that do you have if you're going to let the state use it to someone's detriment? And that's the part that I just don't know how they can do that. And then they're talking about this is exactly what happens in DUI cases. If you've ever had a DUI case, refusal that went to trial, you're talking about what it may infer when the court solemnizes the silence. And that's what we're talking about. The silence is what they're talking about in Griffin, but in the refusal case, it may be anything. It may be your silence. That's considered a refusal. It may be you saying, no, I don't want to take the test. You may be saying, I want a lawyer. Any of those things are considered refusals, and the court has been given instructions to the jury for many years that they may infer that your client's test would have been positive based on that refusal. So I'm going to move forward through we got a lot of cases here. And Miranda's a great case. I mean, Miranda's just wonderful for our arguments that we're making now, because Miranda came up with this concept that when you're in custody, you are going to be coerced. That one circumstance alone is coercive. And that's why Miranda was important. There is a line of cases in Georgia, Bennett, Cobb, and I can't remember the third one, before Miranda was decided, where they found that you could use someone's silence against them when someone made an accusation that they should have responded to. I mean, it was the dumbest line of cases I've ever seen as far as the reasoning goes. And Miranda clearly overruled all of them, but the Supreme Court justices have been asking about that line of cases because they're trying to apply the Georgia Constitution, paragraph 16, to a breath test case rather than the Fifth Amendment, obviously, to a breath test where you have where you can take that breath test as a search incident to arrest. I don't think there's a great argument there, because the reasoning in those cases don't even make any sense. I mean, literally, they're trying to invoke you to make a statement while you're in custody, and therefore, the argument by the state is that you should be able to infer they're guilty by not taking the test in a DUI case. Mallory's another great case that I'm a little worried about with the Georgia Constitution, that they may overturn that, at least the. So this is the warning that I put up earlier. So when you tell someone that your refusal to take a breath test can be used against you at trial, that is the language that the state sees as their big problem. That's why everyone has been arguing the Chicken Little defense on the refusal, because they understand if we win the refusal argument, then the implied consent warning is unlawfully coercive. It is misinforming you that the breath test can be used, refusal can be used against you at trial. So that would, of course, coerce you to take the test. So therefore, the argument is that the breath test should not be admissible either based on incorrect information in the implied consent warning. Now, I submitted to you guys probably 1/50th of the briefs I've submitted to the Supreme Court on this, and it was 150 pages, I think. But I have at least 3 to 5 pages involving this exact issue, and it's Purse, Rojas, Terry, Rowell, Deckard, Renfro, Leviner. It's just a long line of cases we've had in Georgia. Anytime you are incorrectly informed about the consequences of the refusal or the test that would coerce you to take the test, then that test is inadmissible against you. So I think that's why the state is so concerned about the refusal in this case. We'll see if I can play this for you. This is my case out of Douglas County at the Supreme Court. I've got a breath test, a blood test, and a refusal also.
Georgia law requires you to submit to the state-administered chemical test of your blood, breath, urine, or other bodily substances for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this test of your Georgia driver's license or privilege to drive on the highways of this state, you will be suspended for a minimum period of 1 year. Your refusal to submit to the required testing may be offered into evidence against you at trial. If you submit to testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the required state test, you are entitled to additional chemical tests of your blood, breath, urine, or other bodily substances at your own expense and from qualified personnel of your own choosing. Will you submit to the state-administered chemical test of your breath under the implied consent law? That shows me positive or negative. The breath test that I want you to take is what will give me an actual percentage. Okay? And if that's above a .08, then you're not DUI in the state of Georgia. okay? But I had to do that test in order to answer your question about where you're at, okay?
Did anyone hear that? Yeah. If you're above a 0.08, you're not DUI in the state of Georgia. So Judge Detmering in Douglas County found that based on Birchfield, that breath test was admissible even with that incorrect information because it was a search incident to arrest. Obviously was arguing about the Georgia Constitution and all of the issues that we have that I'm talking about today. And the Supreme Court held that case until OLEVIK was decided. I think it was there probably 6 months to 12 months. I don't remember the exact time period. So they held it until OLEVIK was decided. After OLEVIK was decided, they then remanded it to the Court of Appeals so they basically reversed the Court of Appeals denying the petition or the application at that point in time, sent it back to the Court of Appeals for reconsideration based on OLEVIK. Then the Court of Appeals found that they reversed the trial court, said that the trial court was improper, but they said they had to remand it for voluntariness or consideration of voluntariness. So I then appealed that back to the Supreme Court, a petition for cert again, and that's now pending also, where I'm arguing that there's nothing to reconsider. They don't need to go back and rehear the evidence. This has all been on the record. The officer admitted he read it wrong and the whole 9 yards. So I don't know what there's to discuss, but even if he read it correctly, we've still got a problem with the lack of Miranda warnings being read to someone, and then we've got the price line of cases. And I argued this yesterday in Fulton County, not very successfully, I might add. I told the judge, I said, all these prosecutors are telling you to go forward with cases, and that right now the law of the land is that the breath test is admissible against my client. I could not disagree more. If you look at the holding from the Georgia Supreme Court in Price, that case, Stacey Price was told that she was going to jail no matter what, whether she took the field sobriety evaluations or not, because she had a suspended license. The Supreme Court said that under those circumstances, that was custody, and all of the field sobriety evaluations that she did after that point were inadmissible. They didn't do a long analysis. They didn't get into the acts versus not acts, but they found that Miranda was required for those field sobriety evaluations. And what I don't understand is, how is a breath test post-OLEVIK any different than field sobriety evaluations that were given to someone after they're in custody? You've clearly got custody in a DUI case. You're in handcuffs, told you're going to jail. So the custody's not the issue. You're being asked to do something, such as field sobriety evaluations, where they're asking you to act. So how is that breath test any different after you're in custody, after OLEVIK says you've got a constitutional right to refuse those tests, than the Price scenario where you, of course, have a right to refuse those field sobriety evaluations, but she chose to take them without the benefit of Miranda. So I don't think breath tests should be admissible right now if you follow the Price line of cases that hold that you can't be forced to act. Obviously, the judges have disagreed with me on that quite a bit, and that's what I keep hearing, is that that's not the status of the law right now. So that case is at the Georgia Supreme Court right now, and we'll see what they do with it. They may punt it again, assuming that the breath test should be inadmissible, not for Miranda, due process, all the arguments I made back in the trial court, but because of the fact that there is another reason that the breath test should be suppressed, which was incorrect information given to him under Purse, Terry, and all those cases I just talked about. So this is the case in Mackey. This is what helps us for a blood test. In Mackey, a gentleman refused search of his car, and they found cocaine in it. There were 2 people in the vehicle, and the judge in a bench trial said that, well, the driver refused consent to search the car, so I'm going to use that to infer that he knew there was cocaine in the car, and therefore I'm going to find you guilty of the possession of cocaine when there was equal access to that cocaine. Our Court of Appeals got this one right and said that it's assertion of a privilege against self-incrimination, and it's equivalent to it anyway, or analogous to it, as they said, and that just because they invoke their rights under the Fourth Amendment, then that refusal cannot be used against you. So whether you're talking about a breath test or a blood test, you would think under the OLEVIK holdings and this holding that regardless of what you do, the implied consent warning is wrong, and the refusal should not be used against you at your trial. So we've got a lot of things happening at the Supreme Court right now. And I think they've got a problem no matter how they decide it. And this is what I also argued yesterday in front of Judge Besson. The fact that the refusal is going to be used against you at trial is a problem for the state, I think, whether it's blood or breath. That information is wrong. And even if they just admit it, and it does get admitted, but they tell them, and this is what Judge Besson's doing, that's why I'm using this analogy. Judge Besson is right now allowing refusals into evidence, but she's not giving an inference to the jury that there is any incriminating evidence there. She just is letting them do what they want. That's almost worse to me than the inference that the test is positive for alcohol, but that's what she's doing. So she kind of agrees with my argument in Elliott that it can't be used against you. The warning is still wrong in Georgia because it says it's going to be used against you at trial. If it just said it's going to be used at trial, that would be one thing. But if it says against you at trial, that's still coercive in making you take the test rather than refuse. So I think they've got problems with the implied consent warning, and I hope I convinced you of all of that by this time.
So she's just not given a charge?
She's not given a jury charge on refusal, right. That's correct. And I think she's telling the jury you have a constitutional right to refuse a breath test.
Did the justices give you any indication whether or not they're sympathetic to this de minimis? Is it a little violation of the Constitution? Is it a good one?
You should go back and watch arguments. Absolutely not. I did not see any acceptance of that whatsoever. I thought it hit a brick wall with justices. Any questions? Thank you, guys. I appreciate it.